here. All right. Looks like we're running. It's the most wonderful time of year, isn't it? That we've got a lot of things going on, and everything comes to year-end rush. And on top of that, we have technical difficulties, but it's all good because it's a good thing to have a good team. Liz, IT, and others really helpful. So we're up and running, and thanks for being here today. We've got almost 200 people already online, and I think we've got about 300 or 400 more registered. So usually this is about when we start anyway, about 8:05. And my name is Jim Reedy, and I'm an attorney at Sheehan, Finney, Bass & Green. This is the New Hampshire Tech Alliance, the HR Exchange, and this is our annual wage and hour review, our top 10 list from this last year. Before we get started, a couple of quick things. This is the upcoming program. This is next month is we start off the new year. Oftentimes we look at diet and New Year's resolutions and so on, but what we've done the last couple of years is a financial wellness update. And so we have a presentation, and that's on January 17th. It's the do's and don'ts when investing in retirement. And as we all look towards that eventual date when we move on to do something else and hopefully enjoy the fruits of our many years of labor, you want to make sure that you've invested wisely, either through your employer or on your own, or both. And so we've got that presentation coming on the 17th. On February 14th, we do this every year because it's the month of Valentine's Day. And this one is going to be a little bit different than we've done in other years because it's investigating and dealing with sex harassment in the age of remote work. 1/3 to 1/2 of all sex harassment claims in the last couple of years have been electronic, and oftentimes from remote workers, or either originating from or somehow involving remote workers. And we'll be doing a presentation on that. And then in March, identifying an issue that was not really identified or treated for purposes of triage in the last few years with COVID, is identifying and properly addressing mental health issues in the workplace. I will tell you that this is just Wednesday, but this week alone, I've dealt with 3 different client matters involving employee mental health. It is a growing concern during COVID, of course, and our presentation will talk about that. During COVID, again, it wasn't triage, and with isolation and self-medication and just a number of issues, anxiety and depression skyrocketed, along with substance abuse disorder and so on. So an important topic for sure. And EAP is important and useful, but there can be so much more in the tips on spotting these issues and addressing employee concerns, so on. So that's where we are. Now, I'll also say that for purposes of housekeeping, remember, for those that have been a part of this program before, that we send you at the end not only your HR credits for attending, but also a copy of the materials and a copy of the video. And those will be sent to you by Liz Tessick at the end. So no worries. We frequently get that question, and we've got you covered. So here we go with the program. The top 10 rather, 2023 wage and hour violations in New Hampshire, and hopefully how to avoid them in 24. And it has been a busy year for our friends at the New Hampshire Department of Labor. I was dealing with them just yesterday. So what we're going to cover in this presentation is the things from the last year, meaning 2023, wage hearings, inspections, penalty assessments, and the pitfalls for noncompliance on what we would all refer to as common wage and hour issues. And they are truly common. That being said, mistakes can be made all the time, or misinterpretations, misunderstanding. We actually dealt with one yesterday with our friends at Department of Labor with regard to the issues of tip pooling, tip sharing, service charges in the hospitality industry. But there have been others, and we'll talk about that too, because while the law is relatively clear, there are different interpretations. And when you have different administrations come in, whether we're talking about on the federal level in the White House, in Congress, the state legislature, the governor's office, or agencies, both federal and state, there could be different interpretations and different viewpoints and different agendas, frankly, with regard to enforcement of the law. And that's not meant to be a political statement. That is just the reality of things. And again, two people can read the same law and walk away with slightly different, and perhaps even more significantly different interpretations. So that's what we're going to talk about. And there are also common misunderstandings. Well, this is the way we've always done it, or isn't this good enough? And so we'll talk about that and the applications. And so during this, the Q&A is kind of important. So if you have questions throughout, don't hesitate. We'd like to sort of review this with you. So let's get started. This is, again, it was another busy year for us and friends of the Department of Labor here in New Hampshire, and also the U.S. Department of Labor. They were very busy as well. And oftentimes there's a lot of overlap here. There are some unique issues under New Hampshire's wage and hour laws, but there's also overlap with our friends at USDOL, and in particular things like youth employment, exemptions from overtime, and so on. So in this last year, the Department of Labor increased its number of on-site inspections pretty significantly from last year. And last year was sort of if we could call it the first year in 2022 of a post-COVID workplace. They were doing inspections before that, but a lot of them were virtual via email exchanges and document exchanges and so on. So last year got out more, this year even that much more in 2023. So 377 on-site inspections in New Hampshire workplaces. And that was, again, an increase from the year before. And with those increases, typically you see more proposed civil penalties, wage adjustments, and thereby they break them down, as I experienced yesterday with a client, by violation, by type, and by frequency. Those penalties can have a substantial impact, of course, on the workplace. And again, given the challenges and how tight things are, and as many of you know, right now we're in that period of time, which is regrettable, but it's not necessarily tied to COVID. In my entire career, except for 1 year, November to January is the high season for layoffs, and so things are tight, and we're coming through, a period of wage inflation, high unemployment. Low unemployment, and therefore competition for employees. But you're also experiencing a time of tight margins because of a 40% vacant occupancy in commercial real estate, and other pressures, energy costs, and so on. So employers things are tight right now. So the last thing you want to perhaps deal with and communicate to your CEO and CFO is we just got hit with X number of dollars in civil penalties from our friends at the Department of Labor. This year, they collected $447,187 from employers. That is nearly double what they collected last year in civil penalties. Now, what this number does not show is what was actually proposed. The proposed civil penalties were considerably higher than that. This is the number that they actually collected. And typically, they reduce that number through what's called an informal conference with the wage and hour administrator and the inspector and the employer, and sometimes with counsel, sit down and negotiate. And basically negotiate showing either that there was a mistake or misunderstanding in the audit, or that we're showing that, yes, we were not in compliance, but now we're going to be in compliance going forward. And that's what the department is looking for. So typically that's why they would reduce the civil penalties. So again, you're looking at nearly $500,000 in reduced or adjusted and collected civil penalties. And for those that wonder, where does that money go? That money goes to the general fund. It doesn't go to get divided up by the inspectors at the Department of Labor, or goes into the Department of Labor budget. It goes back to the general fund of the state. The wage adjustments, now that's the big one. So civil penalties would be, again, and it's usually a stacking violation, $100 per employee per violation per day. So it can add up fast. And that's when they find a violation and they hit you with the civil penalty. But the stacking is the next time they have a violation like that, it's $250, then $500, and so on, up to $1,500 per employee per violation per day. And you can see how fast that will add up. Well, that's the civil penalties. On the other side, the Department of Labor can assess what's called wage adjustments. And wage adjustments are where they determine that wages were not paid to employees. And what do we think about there? We think about short breaks. We think about not paying a shift differential, not paying overtime, and so on. In the area of hospitality, like I was dealing with yesterday, when tips were not properly administered by the employer or were improperly distributed to, say, non-tipped employees and so on. So you look at that number, and that number is significant. And what is that? The Department of Labor will give you a list of all the employees, the amounts that they determine that you must pay to the employees. And they can look back 12, 18, 24 months. Technically, they can go back 3 years under the state statute. But typically they'll look to a year to 18 months and the furthest back, usually 24 months, for purposes of making wage adjustments. $1.3 million actually collected, meaning the employer had to send the checks off and present proof to the Department of Labor that the checks were sent off. Another way of doing it is send the checks to the Department of Labor for them to distribute. And then if because this is to current and former employees conceptually, and to the extent that the checks come back returned, then the Department of Labor then tries to fine them through Equifax and so on. And if they can't, then the money gets defaulted to the general fund. So a lot of money there, a significant increase from the previous year in 2022. Combined civil penalties and wage adjustments, we're looking at $1.7 million. That's significant in giving what we've been through. Now, again, the Department of Labor is not out to ruin businesses. The Department of Labor is just doing their job, which is a protective statute, and they're trying to enforce this statute as they understand it. And they read the law, they read the regulations, they understand the legislative history, and so on. So that's a lot of money, and that's why we come up with this list of the top wage and hour violations, and hopefully how to avoid them, because that's a pretty significant sting. The other thing to mention with regard to this is, with the wage adjustments, typically those are not reduced unless there truly is an arithmetic or other error. The department does not reduce them because they've done an audit, they've looked at the numbers, and they've determined this is the amount due back to the employees. And if you pay that, they typically will reduce the civil penalties. But they rarely drop the wage adjustments. So, that's a tough pill when you're talking about going to your CEO, your CFO, and saying, in addition to the wages we paid, in addition to the civil penalties we have, we've got to pay out these employees X amount. Now, what typically comes up in that is other employees come forward and say, well, I didn't get paid, or some other misunderstanding, and it's disruptive. The other thing to mention in this regard is, no matter what the department does, say they come up with this number for wage adjustments, an employee can still file an individual wage claim. Again, they can do that within 3 years of when the wages were due. So it's not necessarily the end of the story. Now, that rarely happens. Usually when the wage adjustments are distributed, that's the end of the matter. But it's clear that, or if the department says we're only going to go back 12 months, the employees can still go back even further if they believe they have a valid wage claim. And that's what we see here, that in the last year, that the number of wage claims filed was also significant. 961 wage claims filed by individuals last year. That is an enormous increase, nearly double the amount from the previous year. Now, that could either be because employees were, felt that they were shortchanged in some way, or calls into the Department of Labor, and the labor says, well, you can file a wage claim and this is how you do it. They help facilitate that. Or just it's symptomatic of, we're coming out of the pandemic, and that maybe that individuals feel like, again, that they were shortchanged, or that they have an opportunity to recover some unpaid wages, whatever the issue is. And typically it's a misunderstanding with regard to wage claims. I've got several pending right now at the department, and a couple of them are true misunderstandings with individuals. The problem with the system as it is, though, when an employee files a wage claim, on that very form that you file with the Department of Labor, the employee or the individual signs and says, I assign my rights to resolve this matter to the Department of Labor. And you would think, okay, then is the employer filing a response? Then you would be able to resolve the matter. The department can effectively dismiss it or resolve the matter by some sort of agreed upon amount. That rarely happens. In fact, I can't think of a time when that's happened. If the employer objects and the employee wants a hearing, the employee gets a hearing. And so you could be off on the one hand dealing with an inspector, on the other hand dealing with this one-on-one at the Department of Labor for a hearing. Now here, the wage claims could either go to the Department of Labor or they can go to Superior Court, which again rarely happens because it's a more efficient system for an individual to go instead of navigating through a court system to go to the Department of Labor, which is more user-friendly for the individual. So a lot at stake, no question, with regard to civil penalties, wage adjustments, or individual wage claims. It was a very busy year for our friends at the Department of Labor, and significant risk, financial risk, and disruption to businesses for employers in New Hampshire. So let's go to the top 10 list. And we say, better watch out, better not cry. You just really want to get to a point of avoiding these violations to the extent possible. You know, on LaborNet, we see these questions all the time. And we have a very educated membership in Department of Labor, on LaborNet. And people generally get it and understand it. It's just, there are mistakes made. And it's even the smallest mistake can start to be expensive for an employer, because again, it's per individual, per violation, per day. So let's go to the top 10 list, starting with number 10, and it's failure to have a written safety plan or a joint loss safety committee and a safety summary form as required by the statute. Now, what are we talking about here? We're talking about having, it's not the OSHA 300 log, and you may say, well, we've got that, so that should be good enough. No, that's the federal U.S. Department of Labor. That's not the state Department of Labor. Now, could you have much of the same information on there? Sure, you could, but you also have to have a joint safety committee. What does that mean? That means, and thankfully it changed now 10 years ago, if you've got 15 or more employees, you need to have reported an annual report of workplace injuries and illnesses and what you've done to effectively correct those. You should also have a committee that's made up of equal numbers of management and labor that meets at least quarterly, and you have a written safety plan. You post the meetings and the minutes, and those are available for inspection by the Department of Labor. But basically, it's these you're identifying any workplace hazards like you would under an OSHA 300 report, workplace accidents, reportable accidents, and what you've done to correct the situation. And again, like with workers' comp, we're talking about things that are above first aid, simple bandages and so on. We're talking about reportable injuries at the threshold, which is now over $1,000 in first aid and so on. But my view would be, I'd go even a little bit lower for things that truly are hazardous or a situation that caused injury or illness or aggravated someone's condition in the workplace. So again, reportable, the committee looks at it. The committee says, what do we do? What do we do to correct it? It's usually pretty straightforward, and that's why it's number 10 on the list, because it's not that big of a deal. It's just that if I go back to what happened in the last few years, that was not a priority for a lot of employers. They said, look, we're trying to keep the lights on. We're trying to keep the business running. Yes, we'll mask up. Yes, we'll have one-way quarters and single-use bathrooms, and we'll cut down on the density of meeting spaces and so on. All the things that we know during OSHA rules and recommendations, and just common sense during the height of COVID. This goes beyond that. This is other types of workplace issues, but this predated COVID. This is still a matter of law. It's often overlooked, but it's one that you should adopt. Again, if you've got 15 or more employees, the written safety plan, it used to be you filed it with the department. You just have to have it, and any updates, you keep those as well, along with your safety committee, meeting at least quarterly, posting your meeting notices, and also your action items in your notes. And that is something that will be picked up in inspection. If you don't have it, it's a violation, and that's an easy one to correct. Number 9, undocumented workers. And you think, well, are we talking about this southern border, the northern border? Not at all. What we're talking about here is not completing your I-9s. You think, but I-9s are a federal issue. Actually, it's RSA 275A-4, and it's basically undocumented workers. And you think this person's family came over on the Mayflower. This person's been here for X number of years. You follow the I-9 rules, and John Wilson has done a couple of programs recently with regard to I-9s and what needs to be done. You know, the changes in the post-COVID era with regard to actually viewing the support documents, so on and so on. That's great. What we're talking about is, did you have a completed I-9? Because the New Hampshire Department of Labor inspectors will look at this. And when was it completed? And what are we talking about here? Well, the employee completes section 1, the employer completes its certification section, that it looked at the support documents, column A or column B and C, which is identity and authorization to work in the US. And it was signed off on. When was it signed off on? And you know, that standard of with that 3-day rule. The 3-day rule I would not rely upon, because it should be at the time when you've hired the person and that stuff is completed before the person commences work. The 3-day rule really was related back to, believe it or not, Hurricane Katrina, when it was an issue involving documents really being washed away. Let's focus on the best practice would be to, and I'll go to that now, to having the completed I-9, meaning, and let's go right down to into the bug dust on this. Each section being filled out, the date of hire in the proper place, the birth date in the proper place, and so on and so on and so on. All the sections that need to be filled out are filled out, dated and signed, and the should the employer keep the support information, copies of the support information. As you know, the law doesn't require that, meaning the federal law does not require that. However, you're signing off, meaning you or a representative of your organization is signing off saying, I looked at these documents and they appear genuine on their face. My recommendation, the recommendations of others in our group are, you know what, if I'm signing off on it, keep a copy of what you looked at and say, in good faith, we signed off, that looked legitimate on its face. So, and the department will be looking at that. But again, you want to have that paperwork in place before the employee commences work. What if the person says, you know, I lost my Social Security card, or I need to update this, I've got this application for replacement Social Security card, and so on. Again, the benefit of an ABC list, A being identity and authorization to work, B being identity and C being authorization to work. So you've got either A or B and C. You've got a choice of documents, meaning you, the individual, the employee, has a choice of documents to produce. And if they can't produce one, you can't say which ones they have to produce, but as long as it's on the list, good enough if it appears genuine on its face and it's a valid document. So that's one that pops up in these audits, because again, the Department of Labor has a checklist that they go through. They may come through for another reason. That's an important point to make, that they may come through because an employee called up and said, I didn't get paid my wages within 8 days from the end of the pay period. Or a parent calls up and says, you know, my kid wasn't paid its wages. And then they come in and they do an audit on, well, what conditions was the youth working in? Or they come in to do, based on, again, one complaint or a series of complaints, and they come in and they do a full-blown audit. That's typically what they'll do. They rarely do an individual spot audit. They may be looking, there may be a hierarchy to what they're looking at, but typically they'll come in, the inspectors will come in and do a full-blown audit, and this is on their list. 8 is failure for employers to report or obtain or continue to maintain workers' comp. And as you know, in New Hampshire, you are required to have, if you've got 1 or more employees, you're required to have workers' compensation for them. And that's easy. But oftentimes what happens is the workers' comp will lapse, or you've got independent contractors and say, well, they're not employees and I'm not going to cover them. And we're going to talk about that in a second, because they may not really be independent contractors. They may be employees. But the person's only episodic or part-time. Doesn't matter. If they're an employee, you should have workers' comp coverage. It's short money. And if you don't have it, you could have unfunded liabilities. Meaning the person's healthcare costs and potentially income replacement, which are both parts of a workers' compensation coverage. So it's important to have that and avoid gaps in coverage as well, because if you've let one lapse and then before the next policy takes place, some insurers would say, why would I want to pick up that liability? So I think this is an easy one. The first few are certainly easy. But just make sure that as a part of your risk management that you have that in place, that you've always got workers' comp in place. And you'll say, well, what about other forms of insurance? You can have premises, general liability, and employers' practices, and so on. But workers' comp is unique to workplace illnesses and injuries, and you need to have that. Number 7, failure to pay 2-hour minimum pay for employees' regular rate of pay on a given day the employee reports to work at the request of the employer and work isn't available. That is a mouthful. What are we talking about here? Because this issue comes up all the time on New Hampshire LaborNet. What if I had an employee that works from home and then was called in for a meeting? What if I have an employee that has a hybrid schedule and was called in after hours or was contacted after hours? What if I had an employee that left early and then did some work at home? What if I had an employee who said, I didn't have enough time to get to the training program online, I'll watch it tonight on my own, or on my weekend on my own, or I had a lot of work I couldn't get to, I'll finish it at home? Should all those be covered by the 2-hour reporting? The answer is no. Go back to the statute. This is what we had to do last year, because this issue came up during the pandemic and post-pandemic period with our friends at the Department of Labor, because there was a misunderstanding as to the application of the 2-hour rule. If you go back to, and we did go back to the legislative history, the historical documents that led to the adoption of this statute, RSA 275-43A, and the related administrative rule, 80303, it is when the employer requests the employee to come into work, the employee leaves their home, comes into a workplace, and has an expectation of working a set period of time. Upon arrival, the employer notifies the employee, no work today. We've lost power. There's not an adequate census. We've got surplus staff. We don't need you. Well, the statute says 2 things. One is you can put the person to work and have them perform some other task, and you pay them the rate for performing that task, or you send them home and you pay them 2 hours at their regular rate. This came up, and we refer to it as I think it was the Walmart example, because Walmart years ago had an issue where, and this is a public record, where they were calling in people off shift to attend a cashier's meeting. And the cashier's meeting was 30 to 40 minutes. And they said, but we let people know in advance, and they knew that's what their expectation was. This goes back to the early days of Cindy Flynn as the wage and hour administrator in New Hampshire. And it was, well, what is the person's expectation? Now, that was later codified. And the statute basically says, if the person, and the regs say, if the person expects to work less than 2 hours, say somebody come in to check your boiler or do some other simple maintenance or turning on equipment and so on, and that's all they do, then that's what they get paid for. They don't have an expectation of working 6, 8, 10, 12 hours. The other thing that comes up in that regard is notification. The statute does talk about, the regs talk about, can you notify the person and say, don't come in? Yes, you can, and that's effective. However, if you've tried to notify them and it's not effective and the person comes in, the 2-hour rule becomes effective at that point. Again, if the person has expectation of working more than 2 hours. But what about those other examples that I mentioned? The remote employee that might come in. Well, that to me is, I don't come in with an expectation of working. And if we go back to the cashier example, do I have to pay you 2 hours to come in? There's been a dispute in that regard. So my expectation is I work a full day at home. You're asking me to come in for this one purpose. be careful in that regard, because labor could say that that is effectively the cashier example, which I had an expectation of working a longer day. You're making me drive in from home, which I did not expect. That is commute time. It could be considered compensable time under the Portal Act, because it's during the workday, but it's not a part of my normal workday, because normally I'm a remote employee. Should I get paid for at least 2 hours? So in that regard, you could make the meeting 2 hours, and then you're done. But what about the example of the employee who watches a training program on their own after hours? Should you ask them to do that? My view in that regard, or the person who takes extra work home and works on that, if they're a non-exempt employee, hourly or salaried non-exempt employee, and they're performing that work at home for the benefit of the employer, that is considered to be compensable time, but it's not the 2-hour rule. That would only be for the actual time work. So you would say, if you're performing that work at home after hours, and then you're to record your time. And they'll say, well, you shouldn't have done that because, you should have done it during your normal workday. That's a separate management issue. But compensable time is if they're doing work for the benefit of the employer, that is time that should be paid for. And so it should be recorded and reported to the employer. So the 2-hour rule, and we got labor to agree with us that the interpretation was, when someone is asked to come from their home to the workplace and told there was no work today, that's when the 2-hour rule applies. So again, there are exceptions to that. If the person on their own says, I'd like to go home because I'm not feeling well, I'm attending to a sick family member, which happens a lot now. We're in cold, flu, and RSV and COVID season again. Entirely possible. Then you don't have to pay. You may not have to pay the 2-hour rule. You pay for the actual time worked. But this is an issue that comes up all the time, and that's why it's number 7 on the list. Misclassification of employer-employee relationship. This is under not wage and hour, although there is a companion piece under RSA 275-42, which is the definition of employer and employee. This is under RSA 281A 2, which is the workers' compensation statute. And again, the Department of Labor covers both wage and hour and workers' comp. What this is something that the feds are looking at the U.S. Department of Labor, and very aggressively these days. During the Trump administration, the standard was relaxed with regard to independent contractors. It's like, look, all hands on deck. We don't care how you classify them. That isn't necessarily true, but the standards were relaxed a little bit. The Biden administration went back to the Obama, Bush, Clinton interpretations, basically where you are deemed to be an employee. The presumption is you're an employee unless you rebut that presumption by satisfying various statutory tests. The New Hampshire Department of Labor has its own test under RSA 281A 2, but there's also one under 275-42, which is the wage and hour side of the house. Also, there's one under the IRS test, which used to be a 20-point test, now is 11-point test with some subparts, really going back up to 20 points. The common law right to control test, and so on. What's the bottom line here? The bottom line is the bottom line, and that is that if you have someone who you've classified it as an independent contractor, who should be classified as an employee, you've got a whole host of issues here. Workers' comp being one. You didn't cover them, so you could have unfunded liability for health insurance costs related to a workplace injury. You've got wage and hour issues, overtime, and timely payment of wages, and so on, potentially for an individual that should have been paid those things. You've got unemployment issues, potentially. Again, there's also a separate statutory test under RSA 282A9, Roman 3, ABC test. It's called the ABC test under unemployment statute. You may have unemployment issues for them. You also could have a discrimination issue where you didn't properly treat someone. And also you could have a health insurance issue under the ACA. Really bad. And the U.S. Department of Labor is out looking for misclassified workers all the time. And they've really stepped that up. So is the New Hampshire Department of Labor. And so be very, very careful in classifying someone as an independent contractor. Could someone be an independent contractor still? And the answer is yes. And you just have to be careful in that regard. But remember, if the individual says, I want to be treated as an independent contractor, that really basically has no legal weight whatsoever. That's that person's preference. All the liability is with you as the employer. And I would say that's fine if you want to be treated that way, but that we don't have to treat you that way here. You may go somewhere else and do that and have that organization take on the risk and liability. The other thing is, let's go to the other side of the equation. What if I have a written agreement with an individual as an independent contractor? Do courts and do agencies give some deference to that? Yes, some deference. But again, it must satisfy the statutory test. And what if you satisfy, say, the test at unemployment? Is that good enough for the Department of Labor? The short answer is no, not likely, because they're separate tests and separate agencies. And as we said at the outset, separate potential interpretations and enforcement priorities. So being very, very careful about that way. And what if it's like, well, we've always treated someone as an independent contractor? The answer is, do they satisfy the test today? So it's a part of your HR audit going through and checking these things. Is that properly classified? And we've got tests and we've got sample agreements. If you want, you contact me separately. I'm happy to talk to you about that. So with regard to independent contractors, I think the other thing to mention is that what if someone was an employee and they left your organization and either they've requested to come back or you've reached out to them and said, could you come back? And they'll say, I'll come back, but I'll come back only as an independent contractor. In that regard, you've got to be very careful because if they do what they did before, they're not an independent contractor. They're a resumed employee and say, yeah, but they're not working the same number of hours. Doesn't matter. Well, they're working remotely. Doesn't matter. But they also work for other entities. Doesn't matter. If they do what you do, and let's break down the test right here. Generally speaking, it's right to control. If they do what you do, they do it where you do it, meaning that your place of business. You provide them with the tools and instrumentalities of their trade. You cover their expenses, and you direct them in how they perform the task. That's an employee, not an independent contractor. Now, last week I had a plumber come to my house because clearly I know my limitations. And if he didn't show up, and we've all been ghosted by contractors before, and I had this person ghost me and not show up, and I had to have someone else call someone else. There are consequences potentially when a independent contractor doesn't show up, and if there are costs associated with that. Not true for employees. If an employee doesn't show up, there's potential discipline, but you can't sue them for not showing up. Again, other parts of the tests are, I tell the plumber, I've got a leak. Could you fix it? I don't look over his shoulder and say, now using the proper sprocket or tool, or I would twist it this way and change it that way. And so on. No, I don't. The manner in which he performs the job, as long as the job is done and the leak is fixed, that's all I care about. So can you give an independent contractor certain things? I need this fixed before my wife gets home or I'm in trouble. Yeah, I need this project done by this date. Can you do it by then? I need this done in a certain way, and this is the report or the product I need. Yes, you can do that. You're not managing every aspect of what they're doing and when they're doing it. Again, the word of caution here is be very, very, very careful here. You've got heightened awareness and inspection and very high risks for improper classification or misclassification. So be on your guard. This is a big one. And actually, I would say it could move up further in the list next year. Number 5 is failure to pay all wages due for hours worked. including short pay, short breaks rather, overtime, shift differentials, fringe benefits, and so on. Now, this one is going to be related to another one on the list, and basically this is a catch-all. You take several of the other violations of this list, like timekeeping, short breaks, meal breaks, reporting time, and so on. They result in the failure to pay wages that are due for those hours worked. So that's really, it's a catch-all provision, 275-43. It's just that. But we see this in many of the violations out there, where if the time wasn't properly recorded as hours worked, then the person wasn't paid, and so on. So where does this fall? Basically, this falls upon if an employee performs the work and it's compensable work, should they be paid? Yes. And again, I'm talking about non-exempt hourly and non-exempt salaried employees. Because again, a salaried employee is a different animal. It's a predetermined amount for a fixed period of time without regard to quality or quantity of work. That's the standard for a salaried employee. And I'm focusing on there as a salaried exempt employee. A non-exempt employee, salaried non-exempt employee, and more particularly an hourly employee, if they perform work for the benefit of the employer, whether approved in advance or not, it's compensable and has to be recorded. Do they have to record it under your timekeeping system? They should, but what if they write it on the back of a napkin? What if they report it to you later in an email, and so on? Then it's compensable time and it must be paid. And you deal with them later with regard to, this is timely reporting and this is what we have to do. Because if you don't pay on time, which is another issue on the list, you, employer, are on the hook, even though the employee reported that information to you late. And I'll talk to you about that in a second. But this is a catch-all. And where does the burden fall here? The burden falls upon the supervisor and the employer to monitor to make sure that late night email or text exchange, the not paying attention to an employee completing his or her timesheet, or just putting down what we refer to as the snowman. Here's 8 hours for today. Not good enough. It's the time work commences at the beginning of the day, so the time work ends at the end of the day, whenever that is, and any bona fide breaks, meal breaks, or breaks longer than 20 minutes in duration, it's recorded on that. And every day that has to be captured. And if it's not, again, the burden's on managers and supervisors to monitor that, to make sure that information is in and complete. And when it's not, they follow up with the employee. If they're changing the record, they're changing the record. And what happens, as you all know, because this came up in an audit yesterday, the employee has to initial the change to the time record, even though it was the employee's fault for not entering the time to begin with. To the extent it is adjusted, it must be initialed. Now, initialing, what does that mean in the age of HRIS and electronic records? It means some form of indicating that it was done. The Department of Labor has agreed to an electronic signature or something indicating that, because you might just have an electronic time record and you can't physically initial that, but something indicating, I understand and I agree that this is the change to my time record. Number 4, paying later than the designated payday. I just alluded to that. What does that mean? Employers must pay all wages due to the individual within the period of time set by law. What is that? In New Hampshire, that is within 8 days from the end of the pay period in which the person performed the work. So if I have a weekly pay period, it's within 8 days to the end of that weekly pay period. And the same is true with a biweekly or semi-monthly or monthly pay period if you have that. 8 days to the end of that pay period. So where's the problem? Two areas. One is, I was late. I didn't pay within 8 days. Or there was an improper or unauthorized deduction from wages, withholding from wages that shouldn't have happened. That's a separate issue. That's one that employers get caught in all the time. That's RSA 275-48. So if you want to put a separate note on that, 275-48 basically says, here are the areas on which you can withhold from wages, whether we're talking about proper loans to employees, whether we're talking about offsets. There's a separate one for salary, which is RSA 275-43B, where you can prorate salary and so on. We're not talking about that. We're talking about tuition payments, loan repayments, accidental overpayments, and so on. There's also one, the catch-all, which is section 12 in that statute, RSA 275-43, I'm sorry, 48-12, says that when the employer and employee agree on a withholding and it's for the employee's benefit, not for the employer's benefit, then it can be done. Again, that's sort of a separate side issue, but that gets into not paying all the wages due within the designated period of time. So when does this typically come up? This typically comes up when after the close of the payroll. So if you had a weekly or biweekly payroll that say closes on Saturday or Friday, and all timekeeping must be in by Monday. So Tuesday, the payroll can be reported out. So then payroll can be paid the following, say, Thursday. And the employee surfaces and says, oh, by the way, I forgot to write this down, or I forgot to punch out, or I forgot to punch in. And they give you that information later than when the payroll closed. What are you required to do? You're required to pay within 8 days for the end of the pay period at which the person performed the work. It's like, but I won't have another, it's too late. I already put that stuff into the payroll system. So I won't have another payroll for another week or 2 weeks. Department of Labor finds that as a violation. So what does that mean? You have to cut a separate check, a manual check for that individual for those additional hours that were not reported in to the payroll for that week. And that's a pain in the neck, and that's also expensive. But that's a disciplinary issue where you deal with the employee for getting their time in appropriately, but tread lightly there because it may not be their fault. It may be the manager's fault, or there may be other issues involved. The bottom line is, if it's something that should have been paid, it was wages earned during that pay period, even if they're reported late and you've already got your payroll set for that period, you should report that time out. What if it follows, the person reports that time in well after? Like that payroll was paid 2 weeks ago or a month ago, and all of a sudden this time is surfaced. You pay it then, and you cut a manual check then, unless it's close enough to another pay period. But you indicate on that pay stub what that is and why, and you also document, look, this is the first we heard of it, and as soon as we did, we paid it. Tread lightly. Number 3 on the list, written notification of pay rate. This came up yesterday in a case I had. There were 217 violations of this. And what is this? It means, and the statute, and this is RSA 275-49, and this is an LAB on this, or a regulation on this as well, that says it's a piece of paper, something that when you hire an individual, you outline, here are the simple elements: the wage rate, the pay period, the pay date, and a general description of the fringe benefits due to that employee. Does that mean you have to get into the bug dust on it's a Harvard Pilgrim plan with a high deductible or an HSA and so on? No, you would say you're eligible for benefits, including but not limited to health insurance, life insurance, vacation, and so on. See the handbook or see HR for additional information. That's it. And that's effectively, it's a summary of what you might be eligible for under the fringe benefits. But pay rate, hourly rate, salary, and so on. If there's additional stuff like shift differentials and so on, you can add that perhaps. Pay period, we're a weekly pay period, we're a bi-weekly, we're a semi-monthly. And the pay date. At the time of hire or in advance of any changes thereto. A question that often comes up in that regard is, but I've just changed my health insurance carrier from this company to that company. Do I need to do anything? If it changes the terms, yeah, some written notification changes the terms in a material way. Otherwise, if it's basically the same, that doesn't change. The person is still eligible for health insurance. What about in the case of a pay increase? You getting a pay increase? That should be noted. And so what is involved? It's a notification to the employee, and importantly, the employee signs off acknowledging receipt of that notice. And you keep a copy of that in the person's personnel file. Every time? Yeah. Is an email good enough? If you can print that email and the person signs off on that email acknowledging receipt, yeah, that's good enough. Keep that record. Is an offer letter good enough? Because gosh, we have so much paper. We gave them an offer letter already, and the offer letter said, welcome to XYZ company. We look forward to having joined our team. This is how much you're going to be paid on an annual basis. Maybe you break it down to the payroll installments. This is your supervisor and you're eligible for these benefits. What did it not include? It did not include pay period and payday. And so it's insufficient. What we typically find is it's just gaps. Gosh, we didn't keep track of that. What's the big deal? The person got a raise. What's the complaint? Again, it's a notification. I'm not a big fan of this. Once someone's employed, I mean, it can be back and forth, and the requirement that they initial or acknowledge receipt. But that's the law. And so if you don't have it, it's a technical violation, and it's per employee per day, and that could be expensive. So that's number 3 on the list. And that came up yesterday. Again, I had over 200 violations for this one client. And this is a good client, and they were otherwise very cooperative with the inspection and so on. I'm confident that we'll get these reduced to some nominal amount. But again, it's wage rate, pay date, pay period, and general description of fringe benefits. And in advance of any changes thereto, plus or minus, provided to the employee in advance of the effective date of that change. Simple. But it's one of those little, again, compliance issues as you do your HR audit to make sure that those are in the files and you're maintaining those in one form or another. Number 2 on the list of the top 10 wage and hour violations from 2023, failure to keep accurate records of all hours worked, not recording meal breaks taken, paying for breaks less than 20 minutes in duration. So this gets into, look, we paid from the beginning of the day to the end of the day. What's the big deal? Did you show, and again, this is the statute that talks about mealtime. And this comes up under the minimum wage statute, but it also comes up under the wage and hour statute. Did you, because this refers to the federal standard under the FLSA for purposes of compensable time and hours worked. Short breaks, meaning any break shorter than 20 minutes in duration during the workday. And again, we're talking about hourly or salaried non-exempt employees. Now, we're not talking about salaried exempt employees in this regard. Any short break less than 20 minutes in duration is considered to be entirely compensable. Well, I went by their desk and the person was sleeping. I went by and they ran out to do a Dunkin's run and so on. If it was less than 20 minutes, it's considered to be compensable. Meal breaks, and this is RSA 275-33, I believe. But meal breaks are after 5 consecutive hours work in a workday, an employee should be permitted by the employer to have a 30-minute unpaid work break. Should that be noted in the time record? Yeah, because it's more than 20 minutes in duration. It should say lunch. What if the person takes a lunch break but is a fast eater or eats at their desk? If you permit them to eat at their desk and that break is less than 20 minutes in duration, the entire time is paid. What if you say, we don't care, we'll pay for lunch anyway and take 30 or 40 minutes? Should you note lunchtime on there? Well, over the years, there's been an issue in that regard, and the Department of Labor doesn't care about an employee's health and nutrition necessarily, but the issue there is, did you provide them the time off? And I think having a policy that says, look, you're free to eat at your desk or whatever, you can take a meal break, just talk with your manager about when you take that and so on, but we're going to pay for your time, that's fine. There's also a meal waiver that was in effect, and this is on LaborNet a couple of times recently, and you have a meal waiver where, say the person works a 10-hour shift or 10 or 12-hour shift. Well, after 5 hours, after 5 consecutive hours, you allow them to take a 30-minute meal break. But at the 10th hour, they want to go home. You say, well, no, you have to stay here for half an hour unpaid and have your early dinner or your late dinner, as the case may be. No, the person can have a waiver then. Or if they work a 12-hour shift, look, I just want to go through. I don't want a 30-minute unpaid break, I can use the bathroom and I can have coffee or nutrition or short snack within that 20-minute window. I don't need to take a 30-minute unpaid break. Should you have a waiver there? You certainly could on that second one. Could you do on the first one if a person's work shift is 6 hours? That's all they're asking to work, and say, could you have a waiver in that place? Yes. And all you say in the case of a waiver is, just let us know in those days which you decide not to use the waiver. Instead, you want to take a meal break, and because you have to record that time. So that's really it, but that is where labor will find violations in that regard. So just be careful about, again, we're principally talking about hourly and salary non-exempt employees. And the number one worst wage and hour or most common violation from 2023, working without the proper parental permission slips in place. So what are we talking about? We're talking about 15, 16, and 17-year-olds. 14-year-olds could be working in a family business, but we're talking about 15, 16, and 17-year-olds. There are restrictions on the hours of work, the days of work, the types of work that an individual, a youth, can be involved in. Leaving that aside for a second, what we're really talking about here is the paperwork in place at the time that the kid starts working for you. And what we're talking about here is you need to comply, because this is federal and state, but they're not exactly the same. We'll go to the state because the state is actually more restrictive than the feds in this regard. If a worker is under age 18, an employer must obtain the youth employment certificate working papers within 3 days of his or her first day. I'm going to stop there. I recommend having them in place before they commence work. Why? Because once they're in, you lose track of the 3-day rule, and it's now 4 days or 5 days. I had a case last year where the client, it was the 4th and 5th day violation. And you don't want that, because these are rarely forgiven and they're rarely reduced. And so I would say, and then what you have is, if that's lax, you've got a lax supervisor or manager, they're going to be bigger issues there too. So I'd be very strict in that regard. A kid cannot start working 14, 15, 16 if it's appropriate for the type of work that they can do, because the statute talks about what they can and can't do. And there's prohibited work at certain ages, certainly 15 and 16-year-olds. They have to have that in place. And if a worker is 16 or 17, must have written permission of the worker's parent or guardian before they can commence work too. So really having that in place, and it must be completed, not partially done, but completed by the parent, guardian, and having those things, again, the younger worker, the youth employment certificate in place before the kid commences work. Jen Meckel told me, by the way, that there's a new rule that hasn't made it to the website yet for labor, and it has to deal with interns. A intern, again, can be paid no wage or sub-minimum wage under certain categories. But the question, and it's a subset to an issue, but whether or not someone can work in one capacity as an employer, and as an employee rather, and also intern in another department within that same organization. And labor has said, yes, there may be instances where you can and get paid a sub-minimum wage or no wage as an intern in a separate department, as long as you're not doing the same job. You can't intern in your same job. That's a youth employment issue too, because typically that comes up for younger workers. You can have an intern, obviously 18 to 22, when you're in school age issues. But anyway, that's a separate aside. The biggest issue here is basically saying, be very, very, very strict about having the youth certificates in place at the time, parental and youth certificate in place as appropriate, in place before the kid commences work. And I'm talking about even orientation and so on, having everything done, then having it clear, this is a 15-year-old and these are the hours and days that this kid can work. That's it. And you base it on, the kid's birthday, and oftentimes a lot of employers doing this. And I'm going to be up at a ski area tomorrow doing some training, and they've got this, they have it color coded. There's a name tag with a color for a certain age, and by age rather. So the managers know, if I've got an orange, I've got a green, I've got a blue, I've got a yellow, this is what I have to do with regard to that person. And again, being very strict, the types of work they can do, the hours of work, the days of work. And if during the school vacation or a when the kid's in school, the hours change. And what if the kid is homeschooled? Then you apply the same standard as if the kid was in a school, what those hours or the vacations are for that school district. And being very, very careful. So if I've got the orange tag and I'm a 15-year-old and there's a limitation on my hours in a particular day, a safe rule of thumb would be 15 minutes before that deadline, you're done. Because typically there's wind up time and before the kid punches out and leaves and so on. That is the safest course of action. But again, this is one that labor rarely will forgive. And the violations, the technical violations can be high. Now, so on this list, you have all of these would be violations if you're found to be in violation. Again, it's by employee, by violation, by day, and those can add up. The ones where you would have wage adjustments would be overtime, shift differentials, failure to pay or improper withholding from wages and so on. Failure to pay the 2-hour reporting time, those would be wage adjustments. But it's a big list. It's one, these are effectively, we just move them around from year to year as far as priority, and there are a few others, but these are the most common that pop up from year to year. So the bottom line is we've got to continue to be careful out there. If you go back to the very first slide, almost $2 million in wage adjustments and civil penalties last year. And that's a lot of money. And even if you go to a fraction of that, that could be something that it certainly wasn't planned for or budgeted for and could be harmful to your business going forward. That being said, if it's due, it's due. But let's have a situation in place where we're doing everything we can to avoid being on this list, the naughty list, in 2024. So that's my presentation for today. Thanks for your patience with those minor technical difficulties, and my thanks to Liz Tezik and Kelly Judell and Sandy Rolfe for assistance with this program, but also our technical issues this morning. I hope that was okay. I want to thank you for your patience. And now I think I can go to questions if I can see them up on the I'm having a sort of toggle issue here for purposes of getting to the Q&A. Let's see. Again, sort of a minor technical blip there, but let me go to those are the acknowledgements. But again, reminder here that these are the credits that you'll be getting. This is the SHRM code for today. Liz will be sending out to you an email confirming your attendance, this certificate, a copy of the materials, and also a copy of the recording so you can share with friends.
Jim, this is Kelly. I'm happy to read the questions to you.
Thanks, Kelly. I appreciate it. Yeah, thank you.
Okay. So the first one says, pay for 2-hour reporting does not apply to counties and municipalities, correct?
Correct.
All right, next question. If an employee has accrued PTO and leaves the company, but your policy is to not pay out PTO upon termination, do you have to pay what has been accrued?
The short answer is no, and it varies state by state. Some states, Massachusetts, talk about that it could be a part of the final paycheck. In New Hampshire, the standard is that it's the employer policy or practice or both to pay accrued but unused leave time, then it must be paid in the final paycheck. However, if it is not your policy or practice, your policy would be a written policy. Your practice would be, what have you done before? If neither apply, then no, it is not due to the employee upon separation.
Okay, next one. When needing to pay an employee on time, what if they are a terminated employee and their check has been mailed out as determined previously, but the mail takes 10+ days to get them? Is the employer at fault?
It all depends on when the employer paid it out to the individual, because remember, under New Hampshire law, there are two provisions for purposes of final pay. One is for the if in the event of someone being terminated, it's within 72 hours of their termination date. So we're not talking about the within 8 days of the period in which they perform the work. It's accelerated in the case of a termination. It's within 72 hours of their last day of work, the termination day. In the case of someone who's a voluntary quit and they give you at least a week's notice, when you pay them, generally speaking, you pay them the next regular payday, because they've given you that notice period. What if the notice is greater than a week? Then you can shift it to 72 hours from the last date of work. But in the case of an employee that it terminates, and say you tried to pay within 72, but it was delayed for some reason, and it gets there later, you could technically have a violation, because again, it's a terminated employee within 72 hours of the last date of work. The benefit of electronic pay transfers, a direct deposit, is that you would make that direct deposit. But if you're mailing out the check, you want to show that you've complied with the post date on the check as to when you sent that out. And typically what happens if, the person moved, or the person said, I didn't receive it. If you're sending out a paycheck, my recommendation would be, if you can't do it through electronic fund transfer or direct deposit, you're going to, and can you require the person come in and pick it up? You could, out of their convenience, but you can't require them to do it necessarily. But if you're mailing it out, I would mail it certified return receipt requested, or some way that you can have UPS tracking or something like that on it.
Okay, next question. When union dues are increased, is the employer required to get acknowledgement from the employee for that change in deduction?
Oh, that's a very good question. That's something that typically you wouldn't find very often, because there are not that many unionized employers in New Hampshire. They are largely in the public sector, but I'm increasing their dues, which are deducted from their paycheck. Technically, that does not fall under pay rate, pay period, pay day, and general description of fringe benefits. And because they're a union member, they basically deferred to the union certain things, because it's a collective. It's no longer an individual employer to employee. No, I think a notification is sufficient. Does the employee have to sign off on it? No, because your agreement is with the union, not with the individual. So my view would be that some sort of general notice that effective this date, and again, you're working with the union on that, effective this date, the dues will increase to this amount. But you don't have to have the person sign off on that.
Okay, does wages earned include PTO and other paid absences?
Does wages earned include PTO and other paid absences? I guess I don't understand the question, because wages earned.
Okay, well, maybe this question could be followed up in the feed with an additional question. I'll come
Yeah,
back.
I guess just to complete that thought, Kelly, I think what I would say is, if we're talking about a W-4 reporting year-end, W-2 reporting, not necessarily, unless you're paying out accrued time as a wage. But if you're putting down their wage rate on that statement at the beginning, 275.49, 27 and 49, no, their pay rate is their pay rate. It's whatever their hourly rate is, whatever their salary is, and it wouldn't necessarily include what the value of their paid time would be. But you know what? That person that asked that question, shoot me an email at jreedy@sheehan.com, and I'm happy to answer that question for you.
Okay, so referencing number 3 on the top 10 list, does the pay date in these letters need to be a specific date, or is, quote, payday is on Fridays, biweekly payrolls sufficient?
That is sufficient. And so if it's a Friday, a Thursday, if it's a weekly, bi-weekly, semi-monthly, or monthly, and then you could say paid on the Thursday following the end of that pay period, or whatever it is, that's fine. Because again, if it's semi-monthly, it's going to change month to month. If it's bi-weekly, it's going to change month to month on the day in which meaning the date it follows, but the day will be basically the same. On Thursday or Friday is fine.
Okay. If an employee must travel a long distance to perform construction observation, do we have to pay for travel time if they travel on a non-work day, like a Sunday? This can be 2 to 6 hours one way.
One of my favorite movies of all time is Planes, Trains, and Automobiles. And typically we'll watch that around Thanksgiving. There is an exception under wage and hour law called Planes, Trains, and Automobiles. And I think it was written by John Candy. But the standard for compensable time is, and it's the Portal to Portal Pay Act under federal law, and again, New Hampshire would adopt the same thing, but basically it's this. If I was an hourly or a salaried non-exempt employee, my commute in this morning is about 54 minutes. That's my normal commute. That's where I chose to live, and the distance from where I work, that's my normal commute, not compensable. So from the time I leave my house to the time I arrive at work, not compensable. To the time I arrive at work and commence my workday within my standard work week and work times, that is considered to be compensable time. If I travel outside of that normal work time, my normal commute time and my normal work time, whether it's during that work week or on non-work days, a weekend and so on, the answer is it depends on what I'm doing and how I'm doing it. What does that mean? I'll go to the how first. If I'm a passenger in a plane, a train, or an automobile, passive, and I'm not working, not compensable. If, however, I'm the driver and say my workday starts at 8, and the example here in the question was construction, and I've got to go from my home, my normal commute would be to a workspace, say 45 to 50 minutes, or 30, 40, 50 minutes away. And instead, I've got to travel a considerable distance. But it's at my employer's request to do something, and it's for my employer's benefit. That could be compensable time because it's well beyond my normal commute, and it's for purposes of, and typically what you'll find is I've got to go to this point to pick up these individuals. I've got to go to this point to pick up these materials, supplies, instructions, and so on. That's when my workday begins. Now we're talking about a weekend work. The answer is it depends upon what the request of the employer is and what the obligation is. Could it be compensable time? It certainly could be. There are a few twists and turns to that. So again, to that person that has that question, you can contact me directly, area code 603-627-8217, and I'm happy to discuss it with you.
Okay, we have a few more. This question is, we offer employees the option of signing up to become certified for CPR by attending a session facilitated by an external vendor. Those sessions are after regular business hours, but CPR is required for continuous employment for many clinical staff. Does that requirement mean that employers are legally obligated to pay non-exempt employees an hourly wage to attend the after-hour CPS recertification?
I think the short answer is yes. Now, the reason why I say the short answer is yes is if I could take that certification and use it elsewhere. Like I said, I'm going to a ski area tomorrow, and they can use a professional ski certification at other ski areas. That may not need to be paid by the employer, but if I need that certification to perform my job, if I need that skills test to perform that job, if I need that whatever the certification or license to perform the job I have with the employer, and it's required, then the employer should be paying time for that training. That is considered to be compensable time.
Okay, can you schedule staff for less than 2 hours and pay them as such?
Well, so the answer would be, this comes from our friends at the Department of Labor. Yes, but that should be at the commencement of their employment. They should know when they're hired that the job requires less than 2 hours. If instead what you're asking is, no, their job's normally 8 to 10 hours, but there's some days I'm going to schedule them for 2. The only way you do that, or pay them for an hour, the only way you do that is that they know at the commencement of their employment. You can't otherwise say, this day you're 7 hours, this day you're 8 hours, this day you're 1 hour, and so on. You could run into problems in that regard. So I think depending upon how you do it, if the job regularly is 7 or 8 hours, then if the person has to come in and they work less than 2, you pay them 2. You don't have to pay them more. You don't have to pay them 6, 7, or 8, but you pay them at least 2, the reporting time. That'd be my recommendation.
Okay, can we have an open-ended lunch waiver where the employee decides whether or not they want to take a 30-minute lunch?
Yes, the short answer is yes. It's open-ended, and it's just, they should let you know when they took the lunch and when they didn't. They don't have to say no lunch because you've got the waiver in place, but when they take the lunch, it should be recorded as the beginning of the lunch period and the end of lunch period, as long as that is more than 20 minutes in duration.
Okay, another lunch question. Can an employer require that employees stay on site during an unpaid lunch break?
And the employer requires someone to stay on site during an unpaid lunch break. That could be a safety issue. That could also be an issue of, look, the lunch break is 30 minutes. When you leave premises, you could be gone for longer than that. Can they require it? I mean, it depends upon the workplace. It depends upon safety issues. I suppose you could, because you're basically saying, if we say you can go off site, it's going to be longer than that. And we've got, staff coverage issues and so on. Yeah, I guess it depends upon the workplace, but you just have to be careful in that regard.
Okay, what is the strict definition of work versus interning? In other words, is there a clear definition of exactly when interns are, quote, learning and not adding value to the employer?
Yeah, I mean, an intern basically is someone who is working with the organization in one capacity or another, unpaid or paid, and it would be unpaid if they're getting academic credit for the work. They just can't replace someone do the job that otherwise would be compensable. Meaning, if you've got someone that performs a certain task and you say, I'm going to get an intern to perform that task, if that task is otherwise compensable, then you've got to pay that person. Interns, it should come from high school or post-secondary or college classes, and the person gets credit if you want it to be an unpaid internship. If it's for the benefit of the employer and there's no academic credit, it should be compensable. There are rules that came out in the last year or so, clarifications with regard to interns. And I know that they're in the U.S. Department of Labor website, and New Hampshire doesn't deal with them as much. There was that one LAB that I referred to, which has not been published yet. That's a truly unique situation where someone is working in one capacity and interning in another. You just have to be careful that they can't do all or part of the compensable work as an intern for no wage or a sub-minimum wage.
Okay, if you have not been keeping copies of I-9 documents, is it okay to start and only have some documents? In the past, I have been guided to keep copies for everyone, and if that is not done, to not keep copies at all.
Yeah, the answer is you can change. So if you haven't kept the support documents before, can you start keeping them now? Yes, you can. Do you have to go back and backfill the ones you did not keep? No, you do not have to. If going forward you notice that if you do an I-9 audit, internal I-9 audit, and you determine some of the ones you have in place now are incomplete, can you correct them? Yes, there's a way in which you can correct them under the recertification section 3. Can I go back and ask people for when they provided no support documents and the form was incomplete? Can I correct that? Yes, you can. And there is effectively a safe harbor in that regard. But if the simple question is, I didn't take copies of support documents before, but now based upon the exceptional guidance from that attorney today, that I should be keeping those, can I do that? Yes, you can going forward.
Okay, a couple more. For wages earned, if a manager doesn't enter PTO on a time card and payroll is complete, does this also have to be paid to the employee within 8 days from the end of the pay period?
So if the employer did not put down PTO on the payroll, then presumably, I guess it shows up that the person didn't work and therefore wasn't paid for that day. And then it should have been put down as PTO, and the person had PTO and should have therefore received compensation for that day. Should that be paid within 8 days of the pay period? The answer is yes. And when it's not, and it's discovered, as soon as it's discovered, a manual check should be cut.
Okay. What is good practice for determining holiday pay for employees that work varying hours throughout a week? For example, a 4-day work week, Monday, Wednesday, a 5-hour day, Tuesday, Thursday, etc. Our current policy is to pay all holidays at an average. In this example, 6.25 hours when a holiday falls on one of the employee's regularly scheduled days. I'm a little confused with the question. I don't know if you got that.
No, I get it, Kelly. I think the answer there is, I think the answer is there is as long as you communicate to the employees that what they can expect by way of compensation for a holiday, because holidays don't necessarily have to be paid. It's not a day of work, but you can, if you establish what your paid holidays are, say that in your handbook or otherwise in your onboarding, and the person works regularly 6.25 hours in a regular shift, should they get paid that amount? And if the shift hours vary, then as long as you communicate them on when a holiday falls, this is what you will be paid based upon your average hours worked in the shift, that's perfectly fine. You can certainly do that. It's just really just managing expectations and being consistent in that regard.
Okay, and if an employee owns the company money for purchases, can that be set up as an authorized deduction?
Yes, under RSA 275 4812. The answer is it's for the employee made purchases. And again, we're not talking about uniforms that were required or equipment that was required for the person to perform their job. These are things that are not required for the person to perform their job or required by the employer, like uniforms and so on. This is simply purchases and of goods and or whatever. Can the employer and employee agree on withholding from wages? Absolutely. Should that be in writing? Absolutely. And again, it's for the employee's benefit, not for the employer. Now, arguably, you can say the employer gets the benefit because they get paid back, but the benefit in the purchase and the way in which it was handled was for the benefit of the employee.
Okay, one follow-on question to the CPR question. It says we don't require them to do the CPR certification, recertification through this program. Instead, we offer it as a convenience. Do they, because they need to maintain the certification, do we basically is asking if they still need to pay them?
They do not. That clarification is important. If it's not required by the employer and they can do it on their own, but you just as a convenience, you offer it to them, it does not have to be paid. And again, that is a portable benefit that they could use presumably elsewhere in a clinical setting. So that does not have to be paid by the employer. It's a convenience set up. And it's in that regard, and the question is who pays for the actual training? That's up to the employer. Because again, if it's not required to perform the job, the employer does not have to pay for the training, nor does the employer have to pay for the compensable time, the time spent in the training, unless it's required to perform the job.
Okay, that completes all of the questions.
Kelly, thank you so much for doing that. Really appreciate it. And folks, I really appreciate your attention today. And I know that you all take it very seriously with regard to your compliance with these and many other workplace laws. In fact, next month for the Manchester Area Human Resources Association, we're doing our annual legal update. And we're talking about sort of the evolution of workplace laws in the last couple of years and what's coming up and compliance issues. So look for the MARA calendar. That will be in person in January. I'm not certain of the specific date. I think it's the 14th, but I'm not 100% certain. But these are things that come up all the time. And also thank you for participation in all the She and Finney programs that we put on, the high tech, the Tech Alliance programs. And I mentioned those at the outset, the ones coming up in the next few months. And then a preview, and Kelly can mention this more and with Liz in promoting, but our annual, and I think it's our 36th annual labor and employment law seminar coming up in May. We're going to soon, in the next month or so, announce the date and details. That one sells out early. We usually sell out by at least a month in advance, and that's coming up. But it's a busy time of year. You've got a lot going on. We really appreciate your participation in LaborNet, these programs, and your due diligence in making sure your workplaces stay safe and in compliance. So thank you for being a part of today's program. The very best wishes for a happy holiday season and the best in 2024. Thanks so much.